So why'd you flip me off?
You can do an inspection?
Yeah.
All right.
You don't want to answer my question?
Do I have to?
No, you don't have to. Is there anybody back there?
Yep.
Okay. Can I see?
No.
Give me your license. Truck registration, shipping papers, and I'll look at your log. Is that a co-driver or a passenger?
Co-driver.
Okay, I need to identify the co-driver for the inspection. So,
You don't have to do that.
who's in charge of this traffic stop here, me or you?
Hello, and welcome back to Legal Dissent, where we evaluate your constitutional rights before they're taken away. Today, we evaluate an older video that was submitted by a subscriber for us to take a look at. If you have videos you'd like us to check out, let us know on Facebook, Twitter, or email us. All of our contact info is located in the description below. Also in the description is the link to the original channel, video, case law, statutes, and the contact information of the law enforcement agency involved. Please visit the original video and let them know that Legal Dissent sent you. In June of 2019, Rocky Chevalier Sr. Playlist was driving in a semi-truck through Illinois. He saw a state trooper and displayed his middle finger to the trooper. Minutes later, that trooper pulled him over.
Hello, sir.
There you go.
You all right?
I'm good.
What was the display of the middle finger back there?
What'd you pull me over for?
Because I can do an inspection. That's
Okay.
why.
There are two questions we have to evaluate in this video. First, is displaying the middle finger a justifiable reason for an officer to pull a driver over for? No, you cannot legally be pulled over or stopped for displaying the middle finger to an officer. The United States Supreme Court held in Baumgartner v. United States that one of the prerogatives of American citizenship is the right to criticize public men and measures. And that means not only informed and responsible criticism, but the freedom to speak foolishly and without moderation. This was echoed in Cohen v. California when the Supreme Court held that the government could not forbid particular words without also running a substantial risk of suppressing ideas in the process. Indeed, governments might soon seize upon the censorship of particular words as a convenient guise for banning the expression of unpopular views. We have been able, as noted above, to discern little social benefit that might result from running the risk of opening the door to such grave results. Gestures and actions are protected under the definition of speech as long as they are communicating a message, such as the flag burning case in Texas v. Johnson. A middle finger is clearly communicating a message to the police officer, and this officer received that message. The officer clearly pulled him over to address the display of the middle finger. This type of stop is not lawful and is a clear violation of the driver's First Amendment rights. The officer attempts to use his power to conduct inspections under the administrative search doctrine as a pretext for the real reason he stopped the driver, which we'll get into more later on in the video.
So why'd you flip me off?
You can do an inspection?
Yeah.
All right.
You don't want to answer my question?
Do I have to?
No, you don't have to. Is there anybody back there?
Yep.
Okay. Can I see?
No.
Give me your license. Truck registration, shipping papers, and I'll look at your log.
So you pull me over for what?
To do an inspection.
All right.
The next question we needed to evaluate is if commercial vehicles are subject to inspection at any time without reasonable articulable suspicion. The short answer is yes, they are. The Federal Motor Carrier Safety Regulations of the Federal Department of Transportation allows states to highly regulate the movement of commercial property on the roadway. Under Illinois Section 625-518B-101A, commercial motor vehicles, meaning a vehicle with a gross weight rating of more than 10,000 pounds and is designed to transport property or passengers, is subject to inspection by any officer at reasonable times and in a reasonable manner. So what is a reasonable time and manner for an inspection of a commercial truck? The administrative search doctrine allows government agencies almost free rein to make inspections. This doctrine is also what opens the door for warrantless searches at the border, sobriety checkpoints, passengers being scanned by a metal detector at an airport, or public school students being searched while on school grounds. In relation to commercial trucks, courts have held that the privacy expectations of commercial truck drivers are markedly less than those of the public in general. The trucking industry is highly regulated, and drivers have long been subjected to federal regulation of their qualifications. This diminished privacy expectation allows the government to bypass the driver's Fourth Amendment rights and inspect their trucks because of all of the government regulations imposed upon the trucking industry. However, this inspection power may not be used as a pretext for a stop that was instigated for other purposes. The Supreme Court held in United States v. Knights that the actual motivation of the officer involved in the administrative search matters. In United States v. Orozco, the Ninth Circuit Court of Appeals found that officers who stopped the truck with their administrative powers because they believe it contained contraband breached the driver's constitutional rights with that search. In Illinois, there is especially an issue with officers pulling over truckers for no reason whatsoever, as detailed in a 2018 article when the Belleville News-Democrat interviewed State Trooper Calvin Dye Jr., who said, "That's the one vehicle on the roadway we don't have to have a reason to stop. We don't have to have probable cause. We can stop them just to inspect their truck." Officer Jansen clearly stopped this truck because the driver displayed his middle finger to him. This is evidenced by that being the first thing addressed as he entered the car, and by the anger perceived when he was not given an answer. Displaying the middle finger is speech, especially when directed at a government official, and it is an act which is constitutionally protected speech. The officer used his administrative search power as a pretext to stop the truck and to hassle the driver. This is unconstitutional and a clear violation of the driver's rights.
I'll change that to on duty for you.
Is that a co-driver or a passenger?
Co-driver.
Okay, I need to identify the co-driver for the inspection. So,
You don't have to do that.
who's in charge of this traffic stop here, me or you?
I'm your boss, so I don't know.
You're my
Yeah,
boss?
yeah.
How's that?
I'm a taxpayer. You work for me. Maybe you're not aware of that. Unless you're not a cop. I mean, are you impersonating an officer, or are you
No,
actually an
I'm
officer?
for real.
And your name is?
Right there.
I can't-
It'll be on your inspection.
I can't read that.
Well,
D.W. Jansen.
yeah,
What's your badge number?
5294.
5294. Okay.
Unreal.
I agree. All this because you want to do an inspection. It's gonna. You're welcome to do so.
The officer is clearly rattled and emotional at this point, and I get it. It's not nice or polite to give someone the middle finger. People have a right to feel offended. But at the same time, the First Amendment is there not to protect the types of speech that is acceptable in polite company, but the type of speech that is offensive. And the most protected forms of speech are political speech directed at the government, especially police officers. This gesture here from the truck driver to the police officer is clear political speech. The officer then uses his power to hold the truck driver for a bogus inspection for over 30 minutes as he checks his log, license, lights, cargo, co-driver, and other aspects of the truck.
Okay, are you still refusing to let me identify the co-driver?
Have I refused?
I asked you if I could identify the co-driver.
Okay. Did I say that you're not allowed doing that?
Mr. Weaver, will you come out so I can identify you as the co-driver? This is the state police.
Has he committed a crime?
I'll read you something here in a second.
Okay.
I need to identify you as the co-driver of this vehicle. I'm doing an inspection. Okay, do you have a problem with that? Okay, can I see your driver's license? Okay, now I'm going to read you something.
Sure.
No person shall willfully fail or refuse to comply with any lawful order or direction of any officer authorized by law to enforce this chapter and to perform vehicle and driver motor carrier safety inspections under this chapter. Lawful orders or directions shall include providing documentation and answering questions necessary to determine compliance with the provisions of this chapter. Any person who violates this section shall be guilty of a Class C misdemeanor.
Awesome.
The trooper is reading from Illinois Section 625 518B-103.1, which refers to the section we examined earlier that requires trucks to submit to an inspection at reasonable times and in a reasonable manner. The driver pulled over when he requested. He provided his logbook, license, and all the other information and did not interfere with the officer's attempt to identify the co-driver. Further, the law reads that no person shall willfully fail or refuse to comply with any lawful order. This is an officer who is unlawfully using his administrative search powers as a pretext to stop a driver who flipped him off. This is an illegal stop. All orders that develop from this stop are rendered void and illegal as well. The driver did absolutely nothing wrong and provided way more information than he is legally obligated to do. However, I don't fault the driver for this one bit. He is driving this truck for a living. It's his job to get whatever he's hauling to a specific location by a certain time. He most likely cannot afford to refuse this officer and risk losing his cargo, truck, and job because the officer violated his constitutional rights.
Okay?
Awesome.
So when I asked for his stuff earlier, there was no reason.
Did I refuse to do something lawfully?
I think you did.
You think we can't find it in the book?
It's right there.
Where does it say that I have to identify somebody else?
I said earlier that I had to identify the co-driver.
Did you ask him or did you ask me? Okay, thank you very much for reading. I'm glad you're at least literate. It's sad you can't provide your name when I asked for it.
I'll talk to your carrier on Monday when they're open for business.
Oh, you're more than welcome. I'll give you the phone number now.
Jeez.
According to this trooper's logic, if he had asked for the driver's help to identify Santa Claus or the Easter Bunny and the driver refused, then he would be committing a Class C misdemeanor. Then he threatened to call his employer because he was impolite to an officer who violated his constitutional rights by pulling him over. Wow. What do you all think? Should officers be allowed to pull trucks over for inspections whenever they want to? Do you think that the administrative search doctrine is constitutional? Let us know in the comments below, and we'll see you next time right here on Legal Dissent.